First of all, explain for us the procedural differences between a trial case and an appeal case.
Right. So let me start by saying and making clear that I'm not on the Vybz Kartel team, legal team. And
we know,
it's important to say that because the courts in our country are very careful, and the code of conduct for lawyers, when a case is before a court, they want lawyers to be very careful about how much of the actual substance they discuss in the media.
Oh,
okay, so as an officer of the court, I have to respect that, but I can certainly help you in understanding your questions.
Okay, so explain that question for us. The differences between, procedurally, between a trial and an appeal.
Okay, so in a trial, you are charged with various offenses. In this case, the person would have been charged with murder, conspiracy to commit the murder. What then happens is that a jury is empaneled. So you actually have two judges in a trial. You have the judge of fact, which is a jury. And then you have the judge regarding the law, which is a trial judge.
Okay.
And so the role of the trial judge in a trial of that nature is to manage the case, to ensure that the rules of evidence are correctly applied, and to ensure that the jury gets proper direction as to considering the facts that are put before it.
And the appeal
The
judge?
appeal now is a panel of 3 judges. And so at the appellate court, what the court is most concerned about are questions of law. Have questions of law been properly applied to the trial process?
Okay.
Okay, so the appeal court doesn't normally hear evidence. And that is perhaps what has made the team upbeat.
Oh.
Because it is rare that an appeal court will allow fresh evidence to be adduced. The formal term is to adduce fresh evidence.
Oh.
And you have to go through certain steps. So you have to show first why that evidence was not available during the trial, and you then have to show why you say it is relevant to the consideration of the appeal.
So the appeal is a review.
Okay, so let's look carefully now at the question of the appeal.
Yes.
The appeal is a review as to the grounds of appeal you put forward. Okay? In this particular case, which is a criminal appeal, this is what the court is to do. The court on any such appeal, and I'm reading from the relevant act that governs this process. So the court on any such appeal against conviction shall allow the appeal if they think that the verdict of the jury should be set aside on the ground that it is unreasonable or cannot be supporting having regard to the evidence, or that the judgment of the court before which the appellant was convicted should be set aside on the ground of a wrong decision on any question of law, or that on any ground there was a miscarriage of justice. So let's back up and look at the two things.
Yes.
Obviously, a question, a ground and a question of law is going to look at the relevant laws that apply to the issues in the trial. An example, let's take the adducing of electronic evidence.
Yes.
So in this case, we had evidence of voice notes. We had GPS evidence that was put forward to show where certain things occurred, where calls were terminated, etc. Okay? You have to follow certain rules to put that evidence in.
Okay.
So on a question of law, the appeal court will look and see whether the correct rules were applied in entering that evidence or not. When we now go to a question of miscarriage of justice, the appeal court will now say, okay, we've looked at those questions of law and we've made certain decisions. Do we believe, let us say, some decisions were wrong on the part of the trial judge?
Yes.
Do we believe those wrong decisions there rise to a question of miscarriage of justice?
Okay.
So what can happen is that you lay, let's say, 12 grounds of appeal, which are 12 assertions that there were wrong decisions either by the trial judge or wrong application of facts or wrong facts that were allowed to enter the trial, which led to the cause for your appeal. The Court of Appeal can look at those 12 grounds and say, okay, we find that 5 are valid grounds for you to be concerned about. But when we look at the overall impact on the trial, we don't believe there was a miscarriage of justice. Or we don't believe that it would have necessarily changed the outcome of the trial.
All right, so let's ask you about some specifics, and I don't remember them verbatim.
Yes.
But one of them was that there was a conflict of interest
Right.
on the jury, where somebody did not declare
Yes.
information about a conflict. I don't remember the details.
Okay.
So lying to the court, would that rise to the miscarriage of justice?
Unfortunately, I'm going to be a lawyer and say it depends, of course, on the circumstances that surround that.
Okay.
Okay? With murder trials, you normally need a unanimous decision.
Yes.
So the question of one of those people perhaps having other motivation, I would understand to be a relevant ground of appeal.
Oh, okay. So it's good enough to it's good enough ground
to get you before the Court of Appeal.
So can you tell us anything about the evidence that are admitted?
What I can say is that, as I understand it, one of the pieces of fresh evidence that have been allowed is the question of some of that conduct. And we could understand why that would be fresh evidence.
Okay.
Because even though it may have taken place during the trial, it wouldn't have been evidence that you put forward during the trial. You come to be aware of it either right at the end of the trial or after, and you go to the Court of Appeal and say, hey, this was not available at the trial, or because of the nature of the evidence, we couldn't put it forward during the trial.
So it's a big deal that it is admitted, right? Isn't it a win in a sense for the defense?
Well, on the question that an application was made and the application has been granted, it's good. What it allows the defense team now to do is to put forward their entire appeal, which is excellent for the administration.
Trial likely to...
That's an important question, and I think members of the public and the entertainment fraternity need to understand that there is a huge burden in hearing appeals. Now, I believe this appeal is set to be heard over 3 weeks, if I'm not mistaken, which is a long appeal. A typical appeal may take 3 days.
Okay.
So when you are set to be heard for 3 weeks, that is a long appeal. The Court of Appeal may also be referenced to various parts of the evidence as it was taken during the trial to then say, here is an instance where this evidence should not have been allowed, or here is an instance where we say it affects ground A, ground B. So it's important to have that context because it then will determine how long that Court of Appeal takes to deliver a judgment. Okay? So you may do a 3-day appeal, and that may take 2-3 months for you to get a decision.
In terms of deliberation.
Right.
So the deliberation is the one that draws it out.
Exactly. So if you're now talking about a 3-week appeal, I don't want to put a number on it, but I would think 8-10 months would not be unreasonable. And given the history of time that our courts take to deliver a decision, it would not be unreasonable at all if they took that amount of time. The Court of Appeal can decide to acquit. You go home. No further trials regarding those charges.
Yes.
You're free to go. They can decide a retrial is in order.
Oh.
So your appeal can be allowed, but the court says there needs to be a retrial.
Okay. And the third?
Or you fail and your appeal is not allowed.
Oh, okay.
And you remain in custody and you serve the remainder of your sentence.
Oh, so those are the 3 possible. One of those will happen.
One of those
in the
will
10
happen.
months.
And it's important to understand that success could mean retrial.
Yes, that would be successful
So if there
for the defense.
It would.
Okay.
But it's important to understand, Court of Appeal doesn't consider whether the person was innocent or guilty. What they're looking at is the process and whether
there were any breaches.
Right. And whether justice was done or there was a miscarriage of justice.
Okay, sir.
And at the end of that, they can say, it is so much that you're acquitted. They can say, yes, this occurred, but the right decision is for you to have a retrial.
Thank you. All right, so there you have it. You heard it, right? You're on our stage from Mr. Roderick Gordon, attorney at law. Somebody who knows, okay? All right, still to come right here on stage. Newcomer Naomi Cowan, who makes her very first appearance at Reggae Sumfest, will also be making her debut on this stage.
Right now, I want a meal for share with me and my friend them.
Shano makes his very first appearance at Reggae Sumfest since his incredible